Thank you very much. First of all, I appreciate the opportunity to come in today and talk to all of you. My name is Rob Crown. I'm a Collier County Court judge and I'm running for re-election. By way of background, personal background, my family, my grandparents moved to Naples in 1959, so I've had family here for many years. My parents both graduated from Naples High School. I grew up here. I went to Chatillon Elementary School, East Naples Middle School, and Laley High School. I graduated in 1988. Then I went off to school. I went to Loyola University in New Orleans, got my bachelor's degree there. Came back to Florida for law school. I went to Stetson University College of Law, which is up in the Gulfport, St. Pete area. Worked up there for a year and a half, 2 years, and then I had an opportunity to come back with my girlfriend at the time, my wife now, Terry. We came back in 1997. I had an opportunity to work at the state attorney's office down here. And so Terry and I moved back to Naples in '97. We've been married for 16 years now. We have 4 children. I have a son going into the 10th grade, a daughter going into the 8th grade, another son going into the 6th grade, and our 4th is a daughter who's going into the 1st grade. All of whom, by the way, are also in the public school system, the 3rd generation of Crowns to go through the Collier County Public School System. Professionally, as I said, I mentioned that I came back, I worked at the state attorney's office. I've been a member of the Florida Bar for 19 years. I graduated law school in 1995. And those 19 years are divided up basically as follows. I had about 4 years in private practice. During that time, I handled criminal law, family law, and civil litigation cases. For about 7 years, I worked as a prosecutor, and I prosecuted everything from misdemeanors to felonies, including drug trafficking, habitual felony offenders, violent career criminals. For 3 years immediately before I became a judge, I was working in the Special Victims Unit at the State Attorney's Office. In that position, I prosecuted capital sexual battery cases and various other sex crimes committed against children and adults. And that was from '03 to about '06. And then in April of '06, I was honored to be selected by our governor to serve on the county court bench. And I've been a Collier County Court judge since then, so for just over 8 years now. During my 8 years on the bench, I've presided over all types of misdemeanor cases, county court misdemeanor cases, county civil, small claims disputes. I've also presided over many circuit court matters as well, including circuit court civil issues, juvenile delinquency, juvenile dependency cases, and felonies. So I've handled a wide variety of cases as a lawyer and also as a judge.
You said you're named in '06. Was that to fill a vacancy, or how did that come about?
Well, what happened in '06 is the legislature created 2 new county court spots here in Collier County based on growth. So it was a vacancy, yes sir. And so at that point, anyone who was interested and eligible, all attorneys who were interested applied, and there were over 20 of us who applied for those 2 seats. And we went through the application process. You submit an application. We have a group called the Judicial Nominating Commission, or JNC, which is a 9-member group from our 5-county circuit: Collier, Lee, Charlotte, Henry, and Glade. Some lawyers, some non-lawyers. It's a nonpartisan group. And we were thoroughly vetted. Background investigation, confidential evaluations with our peers. They went over our history, our personal background, and our qualifications, plus an interview with the entire JNC. And based on that, they created what we call a short list. We went from, I think, 21 or 22 down to 6. Those of us on the short list went to Tallahassee, went through the same thing with the governor's staff. Before that interview, we were thoroughly vetted by them again. Based on that, the governor then made the selection. I was one of 2. I was selected to serve on the bench.
What was it back in 2006 that made you decide you wanted to move into judgeship as opposed to continuing as an attorney?
Well, I've always loved being in the courtroom. First of all, I can tell you, going back even further than '06 when I was in law school, that's the first class I ever took, was trial practice, where I felt like this is where I belong. This is what I'm meant to do, something in the courtroom. And so I've always enjoyed being in the courtroom. And then as a prosecutor, I told you I spent about 7 years as a prosecutor, 4 in private practice. So the majority of my background is as a prosecutor. I loved being in court, and I just thought that, I thought being a judge, I thought I could do good things. I thought it was a good opportunity when there were 2 vacancies. for me to put in. Again, I'm very comfortable in the courtroom. I feel like I belong there. And so I had an opportunity to put in, and I did, and it just worked out for me.
What has this job brought you that you didn't expect?
Unexpected results from this job. I'll tell you the biggest surprise for me. I mentioned earlier that at the time that I became a judge, remember I worked in the Special Victims Unit, and I prosecuted many capital sexual battery cases, which, by the way, is a mandatory life sentence if convicted. And so I sat or stood next to people as close as we are right now, asking a judge to put somebody in prison for life, and successfully many times. And then I became a judge. And the hardest thing that I was not expecting was to sentence somebody to 10 days in jail. And I'll tell you why. It doesn't make sense, but in county court, we have a lot of folks who come to county court who are not criminals by nature, right? A lot of folks in criminal court just had a bad Saturday night. And so I had somebody who was otherwise a law-abiding citizen. I remember this was my very first sentence that included jail time. Someone who was otherwise a law-abiding citizen but made some bad decisions along the way on one particular night and ended up going to jail for 10 days among other things. That was very hard for me because, again, I know this was an isolated incident, but I felt the punishment fit the crime, and so I imposed it, as difficult as it was. But that 10-day sentence was much harder than many of the life sentences I requested as a prosecutor.
Also, if you do preside over a wide variety of cases, but if you had to break them down percentage-wise, what do you say you are adjudicating the most?
Well, in county court, first of all, understand the distinction between county court and circuit court. In county court, we have criminal cases, misdemeanors, punishable by up to a year. And our civil disputes, that's based on the amount in controversy. That will determine jurisdiction in a civil case. If it's less than $15,000, you're in county court, not in circuit court. So we have those criminal cases and we have civil cases. We spend about 80% of our time in court on criminal cases. That's in court time. So 20% of our time on civil. That being said, we spend probably more time in chambers on our civil docket, our civil caseload, than we do on the criminal cases. Number-wise, I don't know if this is what you were interested in, but so far this year in Collier County, we've had over 4,000 criminal cases filed. There are 6 of us now, remember. I'm one of 6, and over 2,000 civil cases. So that puts it in perspective and gives you an idea of our caseload.
Do they break those down, like, or you go through rotations where you're doing criminal this week and civil next week, or is it just a mishmash of everything all together all at once?
Good question. It's a definite schedule. Remember, there are 6 judges, so we're on a 6-week rotation. And what we do is and one of us is in each one of those weeks at all times. And we just go around and around during that 6-week rotation. 4 weeks of criminal cases, 1 week of civil. That's where I get my 80-20 split to answer your question. And then we have 1 week that's dedicated to special set. Anything, for example, that might take more than the normal amount of time. A jury trial, for example, that's expected to last a week. Or a lengthy evidentiary hearing that we don't have time for in the normal docket. So we have a 1 week special set week for those purposes.
You said earlier, Judge, that you would hope that, as being a judge, you would be able to do good things. Can you go over some of those things that you have been able to accomplish that you feel have been good for either the community or for maybe a particular defendant or
Sure.
or plaintiff?
As I mentioned in one of my previous answers, I think a lot of the folks who come through county court, again, are not criminals, right? They get themselves in a bad situation. And we see that oftentimes with respect to driver's licenses. We have many cases where someone is charged with driving without a valid driver's license or with one that's suspended or revoked. And oftentimes, not in any one particular case, but oftentimes we get to work with that person and help them obtain a valid driver's license, which may seem like an easy thing to do for some folks, but not for everyone. And so whenever we get to do that and someone is finally done with us, I had a gentleman actually break down in tears about 3 months ago because he came back to court and said, "Judge, I've got great news. I've got my driver's license." So we were finally able to help that person get his license and be done with us, right, and move on and put this episode behind him. That's always a good thing. Another thing that I love to do as a judge, and being a judge has given me the opportunity to do this, is I love to talk to kids, to talk to students. And during the past 8 years, I've had that opportunity. I've been out into the community and I've talked to kids of all ages, from elementary school all the way up through law school. We can do all of that in Collier County now. And I enjoy doing that, talking to them about civics, about the judiciary, what we do in court, the different types of courts in our state system, that sort of thing, the consequences of their actions. So I enjoy doing that as well.
It's not that often that we see judges get challenged in an election. Do you have any perspective on why you think you drew a challenger this time?
That's speculation, but I'll give you my best answer on that. My guess is my opponent views this as a win-win situation for him, and what I mean by that is perhaps he'll win the job, and that's a good thing for him. And if not, perhaps he thinks it's good for business. My opponent is a sole practitioner. He's been a criminal defense lawyer for about 10 years, has his own practice, and maybe he thinks that the exposure would be good for his practice. It's the best answer I can. I'm speculating, obviously, because I haven't talked to him about that, but I'm thinking he maybe views it as a win-win situation.
What makes you the better candidate, or why should people vote for you instead of your opponent?
For a couple of reasons, I think. First of all, I have more experience than my opponent. As I indicated earlier, I've been a member of the Florida Bar for 19 years. My opponent's been a member for 11. During his 11 years, I think it's important also, not just based on the length of time, but also the type of experience that we have. He was a prosecutor for about 1 year, and as I said, for the last 10, he's practiced criminal defense. You may hear my opponent on occasion say, what we mostly do in county court is criminal. He'll say what we mostly do. And I think the reason he's doing that is to minimize the significance of our civil docket because he doesn't have civil experience. So in response to your question, I think one of the reasons I'm more qualified is because I've handled a wider variety of cases during those 19 years. As I indicated when I was in private practice, some of the cases I handled were civil litigation cases. And over the past 8 years, I've handled the docket. Including civil cases. I've got over 500 pending civil cases right now. Over 2,200 have been filed so far this year. So I don't think it's fair to minimize the importance of our civil docket. So I think I'm more qualified because I've been a member of the bar longer. I've got 8 years of experience on the bench, and I've handled a wide variety of cases.
Does a judge in your position have the latitude to pick things to get involved with, for instance, drug court or teen court or things like that? Or are they assigned by the chief judge? And if so, what would you choose to get involved with?
The answer is different for the different things that you raised. To get involved in a specialty court like drug court or mental health court you referenced does require approval or the blessing of the chief judge. To get involved in teen court, that does not require approval of anyone. And yes, judges do have the latitude to do that. I was a volunteer for teen court for several years. Another great opportunity to get involved in the community is the Junior Achievement Program. I've done that for many years. That's a 5-week commitment every time you do that. And I enjoy that because, again, it gets me into the classroom with children. So I do enjoy doing those types of things. We have latitude to get involved in the community, which again is one of the reasons I really enjoy being a judge, is I have the opportunity to do that.
We hear sometimes the phrase judicial temperament. Can you tell us your definition of judicial temperament, or what proper judicial temperament is? Sure.
And I think that when you hear that phrase, you'll hear people oftentimes say that's probably one of the top 3 most important qualities in a judge, right, is to have the proper judicial temperament. What that means to me is this. Every day we go to court and we have people arguing different positions on the same issue, arguing against each other, asking for different things. Obviously, a judge needs to be able to operate in our adversarial system while remaining patient, open-minded, honest. Obviously, you've got to be professional and courteous to lawyers and litigants alike, and yet be firm at the same time. And I think judicial temperament encompasses all of those things.
As you're going through the system, are there efficiencies that you've seen where you've been able to raise with your other judges suggestions on efficiencies for the court system?
Efficiencies and improvements in the system, the way we do things, yes, sir. And we've done that. It would be unfair for me to sit here and tell you that I've done this, I've done that, because there are 6 of us and we work together on these things. And I've worked with my colleagues on a number of issues over the years. Some that come to mind is we've worked with the clerk's office to streamline our procedures with respect to small claims court, to make that a more efficient process. We've worked with our probation officers to more effectively manage our probationers and to more effectively handle our VOP or violation of probation cases. We work with the state attorney's office, public defender's office to more effectively handle domestic violence cases. So the answer is yes, sir. But again, I think it would be unfair for me to sit here and take all of the credit for that when we as judges work together with other agencies to accomplish those efficiencies.
What about in terms of fundraising for the campaign? Have you been supported by Bar Association or any other organizations?
Not in name the Bar Association. First of all, when you talk about fundraising in judges or judicial candidates, you know that's a red flag. And we can't get involved in that personally. We have to have a committee do that for us. So I have, can I rephrase that? Are you asking me where my money has come from during the course of the campaign? Not from the Bar Association as an entity. I am honored to say that I have been endorsed by the current president of the Collier County Bar Association and 14 past presidents. In addition to that, over 100 of our local attorneys have endorsed me. But to directly answer your question, I have received contributions from many lawyers in town and many non-lawyers. Remember, my family's been here since 1959, so I'm lucky to know quite a few people, and I've had contributions from all walks of life, but not necessarily organizations. Although law firms, I guess that's entities, individuals and law firms.
Coming from a prosecutor's background, you found it difficult to empathize with the defendant's side of things, or how do you go about setting aside your past as a prosecutor to look at these cases coming into you as equal?
I received that exact same question when I applied. Remember, I explained the JNC, the Judicial Nominating Commission, and the interview process with the 9 members. And they were, I don't want to say concerned, but they had that question for me. Can you be fair and impartial with respect to criminal defendants if you're primarily a prosecutor as a background? And the answer is absolutely not, because when I was a criminal defense lawyer, I was in private practice for 4 years and I handled a variety of cases. That's when I gained that perspective, and which I've said I think a couple of times here, where you realize that the people in county court are not criminals necessarily who are repeat offenders who are going to keep coming back, but people who simply have had a bad day. And I gained that perspective as a private practitioner, not as a prosecutor. And so I really think that helps give me a well-balanced view of the system. And so I absolutely feel that I can be fair and impartial. I think I have been for the last 8 years, and that's not a problem at all.
You mentioned what roughly turned out to be 6,000 cases among 6 judges. 4,000
so far this year that have been filed.
This year.
Yes, sir.
That seems overwhelming. Is it 1,000 cases per judge?
It's not overwhelming, no, sir, because we work with such great agencies surrounding us, and we all work together. It's a collective effort to continually improve our system and our process to become more efficient. So no, it's not overwhelming. It's manageable because of the system we have in place and the support we have around us.
Do you see any more vacancies on the horizon, or is the circuit pretty well set right now?
Circuit is pretty well set. I can tell you that actually, the way that works is the Supreme Court has a study completed every year on the numbers, caseloads, and that sort of thing. And based on that study, they'll certify to the legislature the need for new judges statewide, county and circuit. And a number of years ago, I can't remember, 2 or 3 years ago, actually Collier County was certified to need an additional or a 7th county court judge. That did not happen, of course, because of budget issues. So the answer to your question is I think we're in good shape. I don't think we need another county court judge right now, and even if we did, I don't think we'd get it. But I don't think we do.
Are there any laws on the books, whether criminal or civil, that you feel need to be changed by the state legislature, or that are just totally, off the wall, odd, either whether it's drug crimes or, especially with the state now looking at, medical marijuana and, then maybe some of the petty crimes as far as, distributing marijuana and things of that nature. Anything like that that's really kind of you've noticed over the past 8 years?
I think I need to steer clear of any hot issues like the medical marijuana, the amendment that's on the table now,
Sure.
only because my job as a judge is to apply the law whether I like it or not. My
Gotcha.
personal opinion is irrelevant. Can I give you an example of a rule that I think needs to be changed?
Sure.
And that is in order to make the system a better system for everyone. And our rules of procedure are promulgated by the Florida Supreme Court as opposed to the legislature, which obviously promulgates the statutes. But we have a rule. I recently have done some work with a statewide agency, a committee actually, to change one of our rules of civil procedure to make the system better and fairer for especially pro se litigants, someone without a lawyer, they come to court. And so there is a particular rule, in this case the one I'm referring to is 1100 subsection C. And my suggestion to this statewide committee was to amend the rule so that it mirrors the federal rules of civil procedure to eliminate a problem that I see. And I can get into specifics if you want to. This particular rule deals with the caption in civil cases. If you're going to be a defendant in a civil case, you're served with the lawsuit, you get a copy of the complaint or the petition, whatever the case may be. And our current status, our current rule, simply requires the plaintiff, the party initiating the lawsuit, to identify one of the defendants and then some sort of indication that there may be others. In other words, the one you see typically is et al., E-T-A-L, right? Have you seen that on a complaint? And then they leave it up to the defendant to flip through what might be a 15-page complaint to determine whether the defendant is actually one of the additional defendants. Are you included in the et al. Or not? And you can obviously will run into a lot of legalese and terms and conditions and arguments in there that you might not be familiar with, which means, and I've had this, what prompted this for me to make this an issue that I'm interested in is I had this a couple of times in court where a defendant ends up in a default status, so a case is resolved procedurally rather than on the merits because a defendant never responds, possibly because they don't realize they need to, if it's not clear on the complaint. And so the federal rule counterpart to that requires at least the initial complaint to include every defendant. Anything thereafter can include the et al. And so I think a simple correction would make a huge difference as far as fairness. And so I'm working with that statewide committee now to accomplish that. But again, with respect to laws and your specific question,
Right.
I apply whatever they give to me. So I think my personal opinion is irrelevant.